Education Law section of the Florida Bar, and also served on the advisory committee for the National Association of Charter School Attorneys.
Thank you. And as I mentioned before, I had the privilege of working for Jeb Bush when he was governor in Florida, and then went over to education after that. And I'm here today to talk a little bit about following up on Dr. Paulson and Lou's presentations as to, okay, if we have concerns, if we have fiscal concerns, and if we have federalism concerns, what are we really going to do about that? And how do we approach that? And what does the Constitution say about it? Now, this is a good group. I like this group because anytime you're talking about what was said in the ratifying conventions of the Constitution, you know, you're getting back to core roots. I'm going to go ahead and do some similar things today because I'm going to try to focus on the actual text of the Constitution, which, as constitutional lawyers will tell you, is very dangerous, and courts rarely actually get to the text. You can read entire opinions and they never actually get to the text. They just talk about all the case law on it. And I've also got something that Ronald Reagan had said in regard to the potential of amending the Constitution by way of Article 5, that you know, there's been some statements that perhaps Reagan's era has passed. Well, I think his wisdom still holds true for today. What I'd like to do is talk a little bit about kind of the only real means that states have to address what I would call a runaway federal government, talking about both the executive and the Congress. And you could put the courts in there with the executive if you want to. And the question is, okay, as a state or as state legislators, what can you really do about it? We've seen some resolutions saying we're going to stand up tall and we're going to stand up for states' rights. And I think those are good, but at the end of the day, they're just that, they're just resolutions. I like what was just presented as far as getting Congress to go ahead and basically make it whereby the states have to opt into the federal programs. But again, I think that, you know, whether Congress is going to actually do that, whether we have the votes, hopefully we do have a good midterm, but I think that that's difficult whenever you ask Congress to try to basically limit its authority. It didn't do it with the balanced budget. It's very difficult to see them doing that in this. It doesn't mean it's not worth trying. That's why I'd like to talk about basically constitutional change. If we're looking for a real meaningful relief, the only way you're going to get that, if we're talking about re-energizing the 10th Amendment, or even putting, as we were talking about and is in the joint resolution, fiscal restraints on the federal government, the only way you can really do that at the end of the day is to get constitutional change. Now, there are three ways that you can basically look at getting constitutional change. One of those ways is changing the makeup of the Supreme Court, because at the end of the day, the Constitution as applied is what the court ends up saying it is. I think there's been some good work done to change the makeup of the court, but even when you have a conservative court, which, you know, right now with Roberts and Alito, we've got one of the more conservative courts we've had in a while now. Even then, you see that there's a reluctance. Roberts, of course, has subscribed to kind of judicial minimalism, which is a little different than judicial conservatism, and he is reluctant to overturn existing precedent that you have on cases. So, because of the bad precedent on the 10th Amendment, even on the 9th Amendment, and other important areas, even changing the makeup of the court is a difficult way to go about it. And of course, as a state, you really have very little input into that. I mean, you can work on presidential elections, you've potentially got the confirmation process in the Senate, but you have very little direct input as a state legislature. Of course, we have the congressional amendment process. And, you know, the problem we have there is that if you look at the balanced budget amendment, we didn't make much progress with the balanced budget amendment because, again, you're asking an institution to basically limit its own power, and that's a very tough sell. The third thing, and what I really want to talk about then, is the option that we have of pursuing a joint resolution. And I'd like to actually read Article 5 of the Constitution here, a short portion of it anyhow. It says, "The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which shall be valid to all intents and purposes," and then it talks about when ratified by the legislatures of 3/4 of the several states, or by conventions in the 3/4 thereof. So what I would propose to you is that this second method in Article 5 of the Constitution here for amending the joint resolutions of 2/3 of the states, is really the only real check that states have on a runaway federal government. There used to be more of a check before the 17th Amendment, which changed the way that senators are selected because you used to have direct legislative input into that. Once that was changed, this is really the only means that you're looking of having a direct impact on the federal government and putting a check on it. Clearly, this is something that in the history of this country has never been done. I don't believe that that means it's something that shouldn't be striven for. I think it means that you have to be cautious going forward. You have to look carefully at what the constraints are. The question that always arises is, can you do a limited constitutional convention? If you look at the text of the Constitution, such as we were just looking at there, there's nothing that would presuppose in the text that you can't. Just as Congress can pass an amendment, which they then submit to the states for ratification, the Constitutional Convention can propose, and it talks about proposing amendments. That plural there, I think it's just talking about, of course they can do amendments, but doing amendments doesn't mean they can't do an amendment. Are there limits that can be put on this? Yes, I think there are limits that can be put on this. Now, there's not a lot of court precedent in this area because we've never had one, and some of these questions will always be open. But I think, for example, that state legislators can condition their call for a convention such that the call is conditioned on it shall address this topic and only this topic, and if not this topic, then it's not a valid call for a convention from this state. And I think you can move through the process, and we can talk about this more in the question and answers, that in the whole process there are ways that you can go ahead and try to limit this both legally and politically to where it's not a runaway convention. One thing that I wanted to say here on the runaway convention is actually, we said we were going to talk about Ronald Reagan. We've got to get his quote in there. This is actually from a radio address he did February 13th, 1979. And they were discussing the balanced budget amendment at that point, except in times of emergency. And here's what he was saying about the method that would be necessary to amend. He said, "I hope we won't lose sight of the main target in a debate over which route we take to amend the Constitution. Some want to call a constitutional convention. Others want the legislative way, with Congress passing an amendment to be ratified by the states. Among these latter, voices have been raised warning of danger that a constitutional convention would open the door to all manner of proposed amendments. In my view, those who warn of this show little faith in our democratic procedures. The Constitution provides for both methods, and the convention is a safety valve giving the people a chance to act if Congress refuses to." And then he goes on to say he'd prefer the legislative way, but maybe it will take the threat of a convention to bring that about. Any number of amendments to end deficit spending have been introduced in Congress and buried in one committee. To talk just a little bit about kind of the runaway aspect of it, I think this is a situation where there are many things that can be done, and it takes longer to discuss, to try to limit both legally and politically the scope of the convention. However, let's look at the harm that's always brought up, the runaway convention. When people talk about a runaway convention, what are they talking about? They're talking about changing the Constitution in untoward ways because of a runaway convention. Well, let me propose that that's what our Supreme Court ends up doing every couple of years with 5 votes. And there's no opportunity for 3/4 of the states to vote on what the Supreme Court is doing. So I would say this is a situation where when you look at the potential risk, and there are risks to having a convention, but there's nothing in life that's risk-free. And you look at the risk of doing nothing, which is leaving the states unilaterally disarmed when it comes to a runaway federal government, every branch of the government. I think the option is you really have to seriously consider going the Article 5 process of joint resolutions by the states to address the issues that have been raised by Dr. Polson and others.
Thanks, Daniel. And we're going to have time for questions here after the last 2 presentations.